Hey guys, and welcome back to today's video. This time we're dealing with a sovereign citizen of the Moorish variety appearing in a Texas courtroom, always a recipe for chaos. Judge Christopher Morales has already denied one dismissal motion filed by the defendant, but apparently that wasn't enough. Today's hearing is all about the defendant trying to get that denial reconsidered, so buckle up and let's get started.
Mr. Davis Bay, can you hear me? I need you to unmute yourself.
Yes, sir, I can hear you clear.
Okay. We're on the record 21 CCR 221014 and 21 CCR 221009, State of Texas versus Antoine Jermaine Davis Bay. Mr. Bay, this is your motion to reconsider. I've reviewed your motion to reconsider. I've reviewed the response and then your reply to the response as well. I'm going to permit 10 minutes per side for argument, and then I'll make a ruling at that time. So, Mr. Bay, you may proceed with any argument you'd like to make.
Okay. So this situation stemmed from an arrest from March 8, 2021, from a lawful arrest without a warrant. Sorry about that. Okay, this is a situation between hypothetical suspicion versus a concrete crime. Whereas in this situation, no concrete crime had took place prior to the unlawful traffic stop. Okay, the state has failed to even establish a probable cause for a warrantless arrest and search, and they had no justifiable basis exist to continue prosecuting this case. The charges of this case do not meet the requirements of actual concrete criminal activity as defined under Texas law and federal law. For one, the absence of a sworn affidavit of probable cause by the arresting officer further renders this arrest unlawful. An injured party or a complaint with a legally recognized injury.
Hey, Mr. Bay, my court reporter is having a difficult time understanding. If you would face the camera, that way your voice could be heard clearly. Thank you, sir.
Okay. Can you hear me clearly now?
Yes.
Okay.
Just maybe slow down just a hair on your speech. Thank you, sir.
Okay, no problem. Okay, well, I'll just repeat what I said. So this situation happened from an unlawful traffic stop without a warrant or a concrete injury from an injured party prior to the traffic stop. I want to make a note also that the traffic stop and the other offense of possession of marijuana was dismissed back in 2021, approximately around the time when the case was first initiated. I did upload and file on record evidence of that notice of rejection as an exhibit.
So what he's trying to argue here is that because one of the underlying charges, the possession of marijuana, was tossed out, every piece of evidence collected during the stop should magically disappear with it. But he's making a huge assumption that if a single charge gets dismissed, the entire traffic stop somehow becomes unlawful retroactively. That's simply not how the law works. A dismissed charge does not erase a valid traffic stop.
Also, I want to point out the fact that this is a case of hypothetical suspicion versus a concrete crime. Okay, the mere act of a traffic stop does not constitute probable cause for a broader detention or search as recognized by Terry versus Ohio. Okay, hypothetical suspicion does not equate to criminal behavior. Okay, in Texas, arrest was searched without evidence of a crime of probable cause contravenes Texas Code Criminal Procedure Article 14.01, Section B, which requires that an offense be committed in an officer's presence or viewed to justify a warrantless arrest. The officer, Jazz Roberts, who was the arresting officer at that time, he did not have any probable cause or reasonable suspicion to even initiate the stop. And then once the stop was initiated, he didn't have any authority to continue with a search or an arrest, especially not just based off a mere traffic citation. Like I noted, that traffic citation was dismissed, okay, indicating that they didn't have any probable cause to prosecute a traffic citation against me. And also the adjoining case that was with it was a possession of marijuana, which was dismissed prior to even we having these hearings.
Like I've already said, getting the initial charge dismissed does not magically make the traffic stop unconstitutional. That's not how this works. The only time your argument would hold water is if a court had ruled that the stop itself was unlawful from the very beginning. In that situation, anything the police found afterward would be inadmissible, and you'd actually have a point to argue. But here, you've got nothing.
Okay, I'll continue on. Failure to uphold due process requirements. Okay, due process under the 5th and 14th Amendment requires fair treatment through the normal judicial system. Due process clause protects against arbitrary government actions, including unlawful detention and seizure without legitimate legal basis. In Texas, due process violations occur when the rights to fair and impartial hearings are denied as well. And this is on the Texas Constitution, Article 1, Section 19. Okay. Also, the officer, as I mentioned, failed to sign an affidavit of probable cause, which is required under Texas Code of Criminal Procedure, Article 1505, subsection 2, which mandates that a written statement establishing sufficient factual grounds for arrest be presented and signed by the arresting law enforcement officer, which I requested a police report from Rosenberg Police Department, which is the arresting agency. I uploaded the results of what I received of that, which is pretty much a blank report, and it failed to have any attached affidavit of probable cause with it. Also, the prosecutor in the last hearing presented me with a discovery, which also failed to present any affidavit of probable cause. Okay. Also, unlawful search and seizure falls under Texas Criminal Procedure, Article 38.23. Okay. The prosecutor alleged the odor of marijuana. The odor of marijuana alone, without physical evidence of probable cause of actual crime, is insufficient to justify a vehicle search. Once again, was no testimony or affidavit of probable cause to.
Honor, if I may, I'm going to object to this. This is outside the scope of the hearing.
Sustained. Let's stay within the scope of your motion.
Well, this was all inside my motion as exhibits and as a brief.
Allegations made by the state were not contained in the defendant's motion.
Agreed. Sustained. Move on, Mr. Bay.
Uh-oh. Looks like somebody completely skipped trial procedure day at imaginary lawyer school. And this right here is the perfect example of why you should always let an actual attorney handle these things. Because winging it never ends well.
Okay. Also, the fruit from the poisonous tree doctrine applies to this case. All evidence obtained as a result of a warrantless arrest and search must be suppressed, case dismissed under the fruit of poisonous tree doctrine, and that's Wong Sun versus United States, followed by citation. This doctrine.
Yeah, Mr. Bay, can you spell that name for my court reporter, please?
Yes, ma'am. Yes, sir. Wong Sun is W-O-N-G, first name, last name Sun, S-U-N. That's versus United States.
You can continue now. Thank you.
Okay. This doctrine bars evidence obtained from unconstitutional actions, including unlawful stop searches and arrests like probable cause. So for these reasons, I request that the court grant this motion for reconsideration to the motion to dismiss for lack of subject matter jurisdiction based on the due process violations, lack of probable cause, and other evidence that's lacking as well. Warrantless arrests, like as I mentioned in my motion and also in my brief. Okay, and I also request that if this motion is not granted, that I could get a full and complete police report to prepare for a defense. Also, evidence supporting the traffic stop and alleged crime that gave rise to these charges that I'm facing with the evasion of arrest and charges of unlawful possession of a firearm. Because for it to be an evasion of arrest, it has to be grounds for an arrest for me to invade. There's no evidence of this. So with the incompleteness of discovery by the state and the failed documentation that the prosecutor failed to provide with a record of events that would normally be captured in a police report, I am prejudiced from preparing a defense, and I'm deprived of crucial information necessary to challenge the validity of the stop and subsequent search. So I do compel that full discovery, and I do request that this matter be dismissed for the reasons stated before.
That's going to be a big, solid no. They're not dismissing your evading arrest charge, and they're not tossing any of the others either, especially not just because you're working with the legal knowledge of a third grader and a wildly inaccurate idea of what actually counts as an unlawful traffic stop. None of that is getting you off the hook.
All right, Mr. Bay, thank you. Your time is up. Your 10 minutes. State, quick question before you respond. Has Mr. Bay had access to discovery in this case? He was admonished for self-representation already. Can you provide how long has he had access to discovery? Does he have access to everything in your file? Please.
Yes, Your Honor. That was actually the first point I was going to make in my response. Mr. Bay, can you confirm the email address that you provided on the docket control order that was signed on July 23rd, 2024?
It was.
Will you spell that, sir?
Last bayby@gmail.com.
And Mr. Bay, is that the same email address that we have received responses from you on October 23rd, November 6th, and November 13th?
Yes, it was.
That is the same email address the state sent you discovery, which would include the PC affidavit that was signed by the arresting officer, as well as the complete offense report that you just told the judge that you did not have access to. That information was shared with you to that email that you just confirmed on October 19th.
I never received any email with a police report, and I requested the police report over 2 years ago.
Did you request it? Who did you request it from?
The Rosenberg Police Department.
Okay. Please send me, I will do my best, but please send me an email immediately following this hearing so that I can provide you a PDF of that document so that we're not going through our portal.
Okay, no problem.
Now, in response to some of these statements or allegations made by defense, again, as I just made clear, the defense has had access to the discovery since at the very least October 19th, 2024. I can't speak to whether the previous prosecutor had shared any of the discovery. I know he was admonished, I believe, on the same date that the docket control order was signed. So we haven't been able to go through actual defense counsel for this, Judge. Again, I will send over in an alternative format the PC affidavit and the offense report so that the defense has access to a complete set of information. On the last setting, I believe it was November 7th, defense was provided copies of all the media, Your Honor. So he does have access, at least from my understanding, to all the discovery. Now, as to points made in his motion, first and foremost, Mr. Bay has not been charged by information with evading arrest. Mr. Bay has been charged with fleeing a police officer as well as a unlawful carrying of a weapon. Now, to his first point of hypothetical suspicion, I do not know where the defendant finds that within the case law. I have not found anything of hypothetical suspicion. What justifies a traffic stop in this particular case is reasonable suspicion. As seen in the PC affidavit, as well as the offense report, the officer had a on-view offense for a traffic citation, which was speeding. The officer attempted to conduct a traffic stop for said speeding, at which time the defendant failed to pull over as required by Texas law. That, in and of itself, constituted fleeing a police officer, which is in violation of the Texas Transportation Code. I believe it is section 545.421. At the time of the stop, the officers attempted to make contact with the defendant. They observed an odor of marijuana. There is case law stating an odor of marijuana alone is enough to support probable cause to conduct a warrantless search of the vehicle, which is precisely what was done here.
I object, Your Honor.
Give me your legal objection.
The prosecutor has failed to mention any case law support his allegation with his brief or anything.
The case law in support of that was in the response to your motion, defense.
Yeah, it was, counsel. Mr. Bay.
Can you please?
Case law makes it clear the odor of marijuana can justify a warrantless search of a vehicle under the automobile exception of the Fourth Amendment. And he goes on to cite Stringer v. State, Rocha v. State, Isaac v. State, and then he even cites additional case law, Cameron v. State. So it is cited in there, overruled. Continue.
So you didn't even bother to read the prosecutor's response. The very document that cites exactly what you're claiming doesn't exist. You'd think that hat he's wearing would at least help keep one functioning brain cell in place, but apparently not. Instead, it just sits there, making him look clueless for absolutely no reason.
Based upon the odor of marijuana, a probable cause search was conducted on the vehicle. Again, this is as alleged by the state, at which point in time, the weapon was discovered within the vehicle as well as the contraband itself. I do not know, again, going to one of the points defense made, I don't know what due process rights are being violated here, which would warrant either suppression or a dismissal as defense has requested. He's claiming that he has not had the right to a fair hearing. PC was found by the magistrate at the time the defendant bonded out. The state has provided copies of that bond paperwork, which was also sent to the defense at the time all discovery was shared. Again, I will re-provide that to the defendant in an alternative way. PC was found by the magistrate, so he's claiming he hasn't had a fair hearing, but the magistrate found PC at the PC hearing at the time that he bonded out. So I'm not quite sure what fair hearing he's alleging he has not had a right to. I know he also made reference to not being able to confront witnesses against him in his motion. We have not had a trial yet. No witnesses have been presented for cross-examination. I will say, and obviously I will provide this to the defense electronically, Your Honor. I wanted to, at the very least, bring this to the court's attention. I have two cases. First is Born, B-O-R-N-E v. State. Citation is 593 Southwest 3rd 404. I have a copy of it for the court. May I approach?
You may. Did you get that citation, Mr. Bay?
Oh, yes.
Similarly, I also have Lewis v. State. Citation is 532 Southwest 3rd 423. In Born v. State, the court makes it clear that arguments such as those the defense is making are sovereign citizen style arguments, which have roundly been rejected by all the courts, all sister courts. In Lewis v. State, they make a similar point. And in that particular point, or in that particular case rather, the judge appointed standby counsel for the defendant. The state wanted to at least put this on the court's radar in that there are certain concerns the state has based upon the filings made by the defendant, and that one of two things is either occurring. Either the defense is filing frivolous motions to delay the judicial process and attempt to coerce the state into dismissing these charges, or alternatively, the defense is unfamiliar with the judicial process. If the latter is the case, the state would be concerned if the defense wasn't provided standby counsel. That's what Lewis v. State is about, Your Honor. Obviously, it is up to the defendant and it is up to the court, or the court's discretion rather. If the defense is going to claim that he's having a bunch of rights violated, I would want to guarantee that we protect these rights as strongly as possible. Again, if the defendant were so inclined, by perhaps appointing him standby counsel.
There are a couple of things worth pointing out here. First, you can tell this prosecutor has dealt with sovereign citizens before. He's so familiar with their recycled arguments that he cites two separate cases calling out the nonsense and highlighting just how poorly these individuals represent themselves. Second, the moment the prosecutor realized just how out of his depth this defendant truly was, he immediately flagged it for the court. He wanted to make sure standby counsel was appointed, so the defendant's Sixth Amendment rights were protected, and so his inevitable guilty plea wouldn't get overturned on appeal due to his own incompetence.
I have nothing further orally, Your Honor. I've made my points in my response to the defendant's motion. Again, this court unquestionably has jurisdiction per the Texas Government Code, as well as the Code of Criminal Procedure. Additionally, based upon the case law I provided in my written response, as well as orally on the 7th of this month, I believe the case law supports the further prosecution of these cases.
All right, Mr. Bay, although you have used your 10 minutes, I will permit 1 minute of rebuttal.
Thank you. First thing I want to address is the due process of that was violated. the prosecutor mentioned that I had a probable cause hearing at the time of the bond. That wasn't the hearing that I alleged that was a violation. I never received preliminary hearing. I never even entered a plea of guilty or not guilty. That hearing had never happened. We initiated this case back in, bond was filed in March 10th, just looking at the docket sheet, Judge. March 10th, 2021. Bond was filed. A hearing for the initial preliminary hearing was not called. The complaint was not even filed until April 27, 2021. So that was a whole 2 months after I was even released on bond, before a complaint was even filed, and no hearing was ever scheduled. A hearing was scheduled for, I'm looking at the docket sheet, a hearing was scheduled for 7/23/2021. It was 2 hearings because at first it was 2 judges. Christopher Morales, and another lady judge. Her name was, and excuse me if I don't have her name right in front of me. But the other case was counseled. The cases was at the same time. So one case was counseled, the other case, I guess, was still heard. And that's when the warrant was issued. But that hearing, we never had a rescheduling that hearing. Once I was arrested again on the warrant and bonded out, that hearing never took place. Also, okay.
That was 2 minutes, actually. So,
all right.
I'm ready to rule. And then I have a question for you as well, Mr. Bay. So I'm going to deny your motion to reconsider. We're going to proceed with trial. And sounds like my understanding, you have had access to the discovery since October 19th. However, he is going to resend everything to you for you to review. My question to you, Mr. Bay, is would you like standby counsel to advise you during trial? They cannot ask questions of witnesses or assist you in that way in the trial, but they can provide advice to you to help guide you through the process.
Yes, I'm not waiving any right to counsel.
Hold on there for just a moment, because you seem to be forgetting something important. You're the one representing yourself. That means you've already waived your constitutional right to counsel the moment you decided to play courtroom attorney without actually being one.
I do reserve my right, Sixth Amendment right to reserve.
You've already waived your right to counsel. You stated you wish to waive your right to counsel and you wanted to represent yourself. We had a whole hearing on that, Mr. Bay.
Okay, so you're asking me, do I want to?
I'm asking you if you've stated you want to represent yourself, Mr. Bay. Okay, we had a whole hearing on that. You waived your right to court-appointed counsel, and you stated you wanted to represent yourself throughout this hearing. And I have confirmed that in almost every hearing that we've held in this case. Now, what I'm offering at this point in time is you can still represent yourself in this matter, but the court would appoint a standby counsel who could advise you during the trial. They're not going to participate in the trial, meaning they're not going to ask questions of witnesses. They will not conduct voir dire, but they will advise you regarding certain legal rights that you may have or on legal matters that may arise during the trial. Would you like the court to appoint you a standby counsel?
Yes.
Yes. So you are asking the court, I just want to confirm, you're asking the court to appoint you an attorney who will provide you advice through the course of your trial, which shall begin on December 3rd.
And I also request that I reserve all my rights. Yes, that's a yes to that question, and I reserve all my rights.
Well, you waived your right to court-appointed counsel already with that whole hearing we went through. But I'm still giving you a court-appointed attorney to advise you, okay? You understand?
Well, I never waived my right to the Sixth Amendment. To the Sixth Amendment.
I can have my court pull the record if you like, Mr. Bay, but we're not going to. I'll tell you what. Do you want to continue to represent yourself?
Yes, I mean, I answered your question. Yes.
Okay. Well, you're stating that you don't want to waive your right. Okay, here's the thing. Do you want court-appointed counsel that's going to represent you during the course of this trial?
Like I answered the question. I said, yes, I would take standby counsel, represent myself.
You're going to take, so you still want to waive your right to court-appointed counsel and continue to try this case yourself, but you're willing to accept standby counsel to provide legal advice only during the course of the trial. Is that correct?
Correct.
Okay. All right.
Can you even imagine the mental gymnastics this guy has to perform? On one hand, he clearly realizes he struggled to answer a basic, straightforward question the judge just asked. Yet, on the other hand, he's somehow convinced he's fully qualified to defend himself in what looks like a pretty serious criminal trial. It's the perfect example of Dunning meeting Kruger at the summit of Mount Stupid. All right, guys, that brings us to the end of the video. He's got another court date coming up for his trial, and if that gets posted online, you'd better believe I'll bring it straight to you. If you enjoyed the breakdown, hit that like button. If not, feel free to hit dislike. Either way, drop a comment down below, and don't forget to subscribe with notifications on so you never miss the next one.